Will's bread and butter. You got to know how to establish a will, and then you have to know how to revoke one. And you have to know, has a will been validly established, and then has it been revoked? So that's what it's all about. They don't just give you one will, they give you two purported wills, sometimes as many as three. Sometimes it's a will with a trust inside of it, a testamentary trust. You have to know what these things are. Big thing on wills: to form it, you need intent, capacity, formalities. Know that if you have a typewritten will, it must come with the formalities of signed in the presence of two attesting witnesses present at the same time during T's lifetime, so on. Memorize those formalities for a typewritten will. And then for a holographic will. How do you perfect a holographic will? In T's handwriting. Material provisions in T's handwriting with some kind of evidence of testamentary intent. Does not, it's signed, but does not have to be dated. And then, is it revoked? 3 ways to revoke: by subsequent instrument, by physical act, by operation of law. Subsequent instrument, that's the easiest, where the second will says, I hereby revoke all prior wills. It would also revoke to the extent of inconsistency between the two. Whereas physical act, you need intent to revoke plus a physical act. Once you have that, once you have those two, then you have found revocation by physical act. Operation of law, that's your omitted spouse, omitted child hypo. You make a will, have a child, child's omitted. You make a will, get married, spouse is omitted. That's all there is. Dr. Johnson, any other ideas?
I think that this is an area where you really, really have to look at a lot of past hypotheticals, because the people who write wills hypotheticals for the bar love to test every possible torturous nuance about formation of a formally attested will. And so they'll twist and turn the facts. You can find most of those twists and turns in past hypotheticals. If I were worried about specific doctrines, I would say this is an area where you have to understand the difference between dependent relative revocation and revival. And I know that people's eyes glaze over about this, but dependent relative revocation is raised by a particular kind of set of facts, and so is revival. And they're virtually never both in the same hypothetical. And as a matter of fact, in California, you're much more likely to see a DRR hypothetical than a revival hypothetical. But you don't want to mindlessly headnote both. What else should you worry about? California law about no contest clauses is pretty restrictive. They're generally not enforced, and that differs from a lot of other states. So know that generally a no contest clause is not going to be enforced by a probate court, but there are 3 circumstances where it will be. Know what those are, at least briefly, and that's not a huge burden. Just take a look at those 3 exceptions where it will be enforced. One of them is where one of the persons who is fighting the will is doing so without any probable cause to believe that there's an abnormality, that there's something that invalidates it. If there's no probable cause, then that no contest clause will be enforced by the court. What else would I worry about? A detail about the law that was tested fairly recently, and sometimes they come back around and do it again, and that involves conservatorships. Understand that just because somebody has a court-imposed conservatorship does not mean that they lack the capacity to devise their own property. And it also doesn't mean that the court automatically has the right to tell the conservator, go ahead and make a will. In California, that's very restricted. Take a look at that law. The other point about California law that differs from a lot of other jurisdictions is about substantial compliance. So we're talking about the formalities. We're talking about a formally attested will and all those highly technical requirements to have a formally attested will. Well, what if there's some little flaw in those formal requirements? Can't we just use substantial compliance and say the will is valid anyway? The answer in California is be very careful with that. The doctrine in California is really restrictive. So I know of one case where a probate court has honored that doctrine, and the facts are really extreme. Don't use substantial compliance to say, oh, well, we didn't meet the formally attested will formalities, but no harm, no foul, we'll probate it anyway. That isn't going to work in California. That's about it for wills.
Okay, that sounds like you got a lot of work ahead of you, but it's all easily doable. And again, these are all spelled out clearly in our power law and in the power lectures that we have in power law as well.